Welcome. We are Group 7 from 3 and 5, and today we are going to discuss the case of Lillian and Mercado et al. Versus Allied Banking Corporation, General Number 171460, July 24, 2007. The parties involved are Lillian and Mercado, Cynthia M. Ficaris, and Julian Mercado Jr., represented by their attorney-in-fact, Alfredo M. Perez, the petitioners, and Allied Banking Corporation as the respondent. Petitioners are heirs of Perla and Mercado, whom during her lifetime owned several pieces of real property situated in different provinces of the Philippines. Respondent, on the other hand, is a banking institution duly authorized as such under the Philippine laws.
We will now proceed to the case facts. On May 28, 1992, Perla executed a special power of attorney in favor of her husband Julian D. Mercado over several pieces of real property registered under her name, authorizing the latter to perform the following acts. The first one, to act in her behalf to sell, alienate, mortgage, lease, and deal otherwise over the different parcels of land located in Kaplan, Oriental Mindoro, Susana Heights, and a personal core property. Second, to sign for and in her behalf any act of strict domination or ownership, any sale, disposition, mortgage, lease, or any other transactions, including quitclaims, waiver, and relinquishment of rights in over the parcel of land situated in General Trias, Cavite, and to exercise any or all acts of strict domination or ownership over the above-mentioned properties, rights, and interests therein. On December 12, 1996, Julian, using the SPA, obtained a loan from Allied Bank amounting to 3 million pesos secured by a real estate mortgage constituted on transfer certificate of title number RT 18206, registered with the Registry of Deeds of Quezon City. He further obtained a loan amounting to 5 million pesos from the respondent using the same subject property as security. However, it appeared that no property identified in the SPA or TCT number RT 18206 and registered with the Registry of Deeds of Quezon City. What was identified in the SPA instead was a property covered by TCT number RT 106-338, registered with the Registry of Deeds of Pasig.
Subsequently, Julian failed to pay the loan and the property was foreclosed where the respondent was declared the highest bidder. Petitioners initiated with the RTC that the SPA at the time the loan obligations were contracted no longer had force and effect since it was previously revoked by Perla on March 10, 1993. Petitioners likewise alleged that, together with the copy of revocation of SPA, Perla in a letter dated 23 of January 1996 notified the Registry of Deeds of Quezon City that any attempt to mortgage or sell the subject property must be with her full consent. RTC decided in favor of the plaintiff. RTC rendered a decision declaring the REM constituted over the subject property null and void. For Julian was not authorized by the terms of the SPA to mortgage the same. CA reversed the decision. The appellate court declared that Perla intended the subject property to be included in the SPA. She executed in favor of Julian, and that her subsequent revocation of the said SPA not being contained in a public instrument cannot bind third persons. Respondent eventually asserts that it exercised reasonable diligence required of a prudent man in dealing with the subject property. Elaborating, respondent claims to have carefully verified Julian's authority over the subject property which was validly contained in the SPA. It stresses that the SPA was annotated at the back of the TCT of the subject property. Finally, after conducting an investigation, it found that the property covered by TCT number 106338, registered with the Registry of Deeds of Pasig, referred to in the SPA, and the subject property covered by TCT number 18206, registered with the Registry of Deeds of Quezon City. are one and the same property.
Now the issue is whether the respondent is a mortgagee in good faith. Based from the Supreme Court, the bank is in bad faith. The respondent is not an ordinary mortgagee, it's a mortgagee bank. As such, unlike private individuals, it is expected to exercise greater care and prudence in its dealings, including those involving registered lands. As a banking institution, jurisprudence stringently requires the respondent should take more precaution to ascertain the status and condition of the properties offered as a collateral and to verify the scope and the authority of the agents dealing the case. The failure of the respondent to investigate into the circumstances surrounding the mortgage of the subject property belies its contention of good faith. On a last note, the Supreme Court found that the real estate mortgages constituted over the subject property are unenforceable and null and void, as ruled by the RTC. It is best to reiterate that the said mortgage was entered into by Julian on behalf of Perla without the latter's authority and consequently unenforceable under the Article 1403 of the Civil Code. Unenforceable contracts are those which cannot be enforced by proper action in court unless they are ratified because either they entered into without or in excess of authority or they do not comply with the statute of frauds or both of the contracting parties do not possess the required legal capacity. An enforceable contract may be ratified expressly or impliedly by the person in whose behalf it has been executed before it is revoked by the other contracting party. Without Perla's ratification of the same, the real estate mortgages constituted by Julian over the subject property cannot be enforced by any action in court against Perla and or her successors in interest. The mortgagee cannot close his eyes in the defect of the title. With these the Supreme Court rules, wherefore in view of the foregoing, the instant petition is granted, and the decisions rendered by the Court of Appeals are hereby reversed. Moreover, the decision of the RTC is hereby reinstated and affirmed with notification that the real estate mortgages are not null and void, but unenforceable.